So Claire, are we good to go?
Yes, go ahead.
I believe we are okay, fantastic. Well, first of all, good morning, good afternoon, good evening. My name is Charles Jallo, and it's a pleasure on behalf of myself and the American Society of International Law and the International Nuremberg Principles Academy, of course, me representing the Center for International Law and Policy in Africa. It's a great delight to welcome you to the International Criminal Court Colloquium Series for 2022. We are very delighted to be kicking off with an event that would focus on Africa, the Ukraine crisis, and international law, called Vadis. As all of you know at this stage, we had a famous event on the 24th of February 2022 with the Russian Federation's use of force in Ukraine. And we all know the justifications that were given by the leader of the Russian Federation. And of course, the response of the United Nations and the international community with respect to that initial event. So I'm going to invite our partners. I'm going to say a few things in a minute about the program, but I'll just invite our partners to welcome you to the event. So I'll start with Mr. Wes Rist, who is the Deputy Executive Director of the American Society of International Law, and is going to give some welcome remarks. He'll be followed by Mr. Klaus Rackwitz, who is the Director of the International Nuremberg Principles Academy. Wes?
Thank you, Charles, and it's my pleasure to speak with you all today. I do want to pass along the regrets of our executive director, Mark Agrast, who wishes he could have been here. He's actually at the World Justice Forum this week, taking part in conversations and leading some discussions there, and very much engaged in that audience as well. It's been our pleasure to partner with SILPA and with Charles as this series has entered its second year now. We're very excited about the conversations that this has provoked and the opportunities for discussion and deliberation that this kind of engagement has opened up. We're very interested, as the American Society of International Law, I should say, for those of you who don't know, is a 116-year-old professional membership association for international lawyers. While American is in the title, actually 40% of our members come from outside of the United States. So we have a very diverse membership who are very engaged in global issues related to international law, frequently targeting specific issues relevant to certain geographical areas and territories. For example, Professor Halal is one of our co-chairs of our Africa interest group, which has been extremely proactive during the pandemic, especially in holding series of events called the Africa Talks series, on specific issues on a broad array of international law topics outside of international criminal law as well. And so we're excited to be able to support opportunities like this for the broader international law community to engage with voices, specifically in the case of SILPA from Africa. I do want to offer the opportunity for folks who are interested in cooperating with ACIL and organizing events and the like. We are a member-driven activity. So when people come up with ideas to do programming, that is what drives our activities and our events. And so if you're interested in doing those kinds of things, ACIL is a forum for you to be able to collaborate and cooperate, and we're happy to assist in that way. I don't want to take up any more time because I'm actually very interested in the conversation. So Charles, let me turn things back over to you.
Thank you so much, Wes, for your welcome remarks. Let me turn it over actually to Klaus Rackwitz from the International Nuremberg Principles Academy to give his own welcome remarks. Klaus, you have the floor, sir.
Thank you very much, Charles, and good afternoon, good morning, good evening to everybody who is listening, hopefully around the entire world. It's a pleasure and a privilege to be again a co-organizer of this event, which is initiated and largely driven by SILPA and by Charles. The topic of this event and couldn't be more timely and more relevant. It is the first time, at least that I am conscious of, that we see a blatant violation of Article 2 of the United Nations Charter 71 years after the judgment of Nuremberg was rendered, and where the Nuremberg principles actually were crafted out and later by the International Law Commission. And Principle 6 crystal clear says that waging a war of aggression should be punished under international law. So what one would naively expect is that there is a unified view on that, and that the United community stands together, but we are far away from this. And it's worth to be noted that although we do have a united view, I thought so far, on the Nuremberg principles, we see that some states, even member states of the ICC, remain silent, abstain in the United Nations General Assembly resolution, where this Russian act of aggression is actually condemned. Among them, states like Uganda and Mali, who themselves have referred situations to the ICC, and now these states remain silent or even invisible. Of course, the vast majority of states is on the right side, as I would say, but still there must be reasons why this is not the case, and there must be reasons why, even after 71 years after the judgment of Nuremberg, there seems to be no unified opinion on that. And that raises, of course, the question, what can the like-minded community do? How can we reinforce, how can we convince, maybe not yet convinced states that this cannot be unanswered, and that this requires a genuine answer of all of us. The International Nuremberg Principles Academy, for those who do not know us, is a foundation established in Germany by the federal German government, the Free State of Bavaria, and the city of Nuremberg. But we are not a government agency, and we are not doing advocacy. What we try to do is to actually spread the word about the Nuremberg principles, support the fight against co-international crimes, support those who will pick it up, and after that, who also spread in their own capacity building activities the good words of the Nuremberg principles. We are located in Nuremberg. Actually, I'm sitting 2 stairs below the historic courtroom in which the judgment of the IMT was rendered. And we open our house for guests, for conferences, for exchange, and for dialogue. I do hope that we will not have to talk too much about Russia in the coming years, but that we can actually state that the vast majority of states has unified in condemning this activity, and that we make all efforts to bring this war to an end. Such an event like today may help, and I'm very grateful for Charles, as I said, and for Wes to be co-organizers with SILPA and with ASO. And that's from my side. Thanks very much. I'm looking forward to a great discussion.
Thank you so very much, Klaus, also to Wes for your warm words of welcome. On behalf of SILPA, it's also a great delight to welcome all of you. We have very much benefited from this collaboration, which we began last year, as both of the speakers mentioned, and we're hoping that we'll continue that collaboration so that we can err on issues of international law of particular relevance to African states. SILPA, of course, of the 3 institutions that you've just learned about, or at least know of, in terms of the American Society and the Nuremberg Academy, is in a sense the baby in the room. It's an independent and non-partisan think tank that aims to shape discourse and build bridges between research, policy, and practice on issues of international and regional law in Africa. So this engagement today is part of that effort, where we want to highlight and bring together an international group of experts, but also African experts, to share their views on contemporary issues of relevance to African states. And I think Klaus already alluded to aspects of the reasons why we decided to convene this event today, which is really to understand the wider context in which these current events are taking place. So I'm very delighted that we have some foremost experts who has agreed to join us for this event today. And we're hoping that in the next several weeks, we'll convene additional meetings that would focus more broadly on the same theme of Africa, Ukraine, the Ukraine crisis, and international law, but picking up on several different aspects of that conversation. For the conversation today, though, we do want to approach it from a general perspective of public international law, in particular from the Assembly, including the resuscitation and use of the Uniting for Peace resolution, which basically opened the door for the General Assembly to act in the face of inability of the Security Council itself to take measures with respect to the situation in Ukraine. Of course, as a general matter, and this is just going to be a very brief point that I want to make before I introduce the panelists, this is not the first time that a state member has decided to use force for reasons of its own, perhaps in violation of the UN Charter. And of course, we've had instances in the past, if you think about the invasion of Iraq, Kosovo, and Libya by Western states, this can be seen as other prominent examples. The most recent use of force, of course, takes place in a wider context of antagonism between different parts of the world, and in a sense raising some fundamental questions about multilateralism and the rule of law in international affairs. The particular aspect, of course, that we hope will drive this conversation today is to appreciate the view of African states, which on balance have been active, but in some respects have been relatively quiet on the particular issues that are now confronting the international community, in particular the international legal questions. On the one hand, one might say many African states have generally supported the multilateral efforts against this particular action within the context of the United Nations system, whether it's in New York or in Geneva. On the other hand, there's also a significant number of African states that have abstained from supporting resolutions. Of course, some have been quite loud on this issue. So if you think about the role of Kenya as a state on the Security Council, but you could also contrast that with the views of South Africa, which wanted to have more opportunities for diplomatic engagement. So we're very delighted at SILPA, together with the American Society of International Law and the International Nuremberg Principles Academy, to convene this interactive dialogue, which we really hope will be interactive, not just among the panelists, but also with you in the audience, to pick up on some of the big questions that arise. For example, one might note the reference that Klaus made to Article 2.4 of the UN Charter. We could also talk about the exception for self-defense in Article 51 and link that to the argument that has been made by this particular state that is using force in this instance. There are questions of state responsibility. One could highlight issues relating to the crime of aggression, the right of self-determination in international law, and so on and so forth. So in the end, I want to pause because I don't want to be, of course, the person who would take us that direction, because we have some foremost experts who have agreed to be part of this conversation today. And I'm very delighted to introduce each of them very briefly. And our hope is that once we introduce them, I'm going to go right to the questions. We've agreed that the format will be to have a series of questions so that the dialogue is quite interactive. And at one point, I'm going to turn to you, the audience, and invite you to bring your questions or to make your contributions in terms of the issues that we'll be discussing today. So let me start with the introductions very briefly. I mean, all of these are distinguished experts. Some of you may know them already, but I'm definitely not going to do justice to their really extensive CVs. I'm going to start with Professor Dr. Erika de Vet, who is a professor of international law currently at the University of Graz in Austria. Erika de Vet is a well-known expert on the United Nations and international law. I mean, it's written extensively on every number of the issues that we're discussing today, whether it's the Security Council, the use of force in international law, even questions of international criminal justice. And I'm going to pause there because, like I said, I could go on and on about her many accomplishments as a scholar and a key figure in international legal scholarship. So I'm going to introduce next Professor Dr. Phoebe Okowa, who is a professor of international law at the Queen Mary University of London. And I'm very delighted to say a member-elect to the International Law Commission. And I say that I'm very delighted because, in fact, Phoebe is going to be the first African woman who will serve on the International Law Commission, where I have the great honor of being a member at the moment. But it's going to be really exciting for me to have Phoebe join us when her term starts in January of 2023. So I'm really excited for Phoebe, not only for the conversation today, but for being hopefully a good friend and colleague on the commission over the next 5 years, starting in 2023. Last but not least, Dr. Mohamed Helal, who is an associate professor of law at Ohio State University Moritz College of Law. And I'm really pleased that he could be part of this conversation, not only because he's also a very well recognized expert, but a member of the African Union Commission of International Law. And the reason why I want to highlight that in particular is the connection between regional codification efforts, in this case by the African Union Commission on International Law in the African space, a very, very important institution. But on the other side, of course, the work of the International Law Commission, which essentially furnished the basis for the model that Africa developed at the regional level in the form of the African Union Commission of International Law. As you can see, we have really, really fantastic experts. So I'm going to pause there and not continue with their bios. Rather, what I propose to do is actually go to the plan that we have agreed, which is essentially, as I said earlier, for me to pose some questions, opening questions that they would weigh in on. And then, of course, I'm going to turn it to the audience, as I said, because we are hoping that the audience wouldn't be too shy. We've actually set up a format that allows for you to engage directly when you're invited to do so. So in the meantime, if you have questions that you think you want to put in the chat, feel free to do so as well, because in some cases, not always the case, the individuals want the floor, although we do encourage that as well. So the chat function is available at the bottom of the screen. I think we all know how to use it. We're happy to give assistance if necessary. Claire is on standby and she's been fantastic. She's works with us at SILPA. She's been fantastic in doing a lot of work for this event, but also other SILPA related events. So let me begin the discussion. I'm going to turn right now to that discussion right on time at 20 past the hour. And I'm going to start out with a general opening question for each of the panelists. And what I will do is I'm going to start with the Professor Dr. Devet. Erica, I'm going to say Erica from now on to make it a bit less formal, more interactive really. And then I'll go to Mohammed, and then afterwards come to Phoebe. And I'll be switching the order as we go along. So there's just in terms of just making it more equitable as we go along. So I'll start with you, Erica. So Erica, can you start us off by sharing as a general matter what you believe are the key international legal questions that arise for Africa from the perspective of this recent events with Russia's invasion of Ukraine, especially if you situate that context in terms of international law as a whole, more broadly.
Thank you, Charles. Thank you for your warm words of welcome, for organizing this event and for being a part of this wonderful panel. I will just make a few brief remarks, and we will continue and delve into some of these comments as we go along. And to me, the one thing that stuck out during this incident is that it affects many aspects of international law, and you've indicated that in your remarks. And Africa also has to re-internalize. International remains a decentralized system. We'll come back to the Security Council specifically later on. But despite that, the implementation is decentralized, and part of the decentralization is regionalization. And Africa has the AU, and there are many structures in place on paper, but I do think one has to reassess how we can make that work better also for Africa. Because if you now turn to Europe, you see that also in the context of the response, you have countermeasures in the form of sanctions. Now, that is, these unilateral sanctions outside of the context of the United Nations Security Council has, especially in developing countries, often been regarded with a sense of suspicion. But that is something that Africa may wish to reassess, because depending on the context, it may be a necessary or proportionate measure that could be used. And so I think that's an area, reassessing how the AU could either internally within Africa or externally vis-a-vis other regions and countries use countermeasures and sanctions in a particular context. perhaps do we need to, because it's been critical of this notion of sanctions vis-a-vis, always, but maybe that needs some reassessment. I think it's very important that African countries try and implement the ICC statute in their domestic legal orders. Many African countries which are a member have not done so yet. And very interestingly, there will be also, the International Criminal Court is now being reactivated and perhaps has a chance of redeeming itself after having made some grave errors in the last 10 years. It is involved in investigating the situation in Russia. This may, over time, lead to prosecutions, but it's very interesting to see what will happen in the decentralized way, because we've already had prosecutions in Germany and in Austria of former Syrian officials in the Syrian conflict who have committed war crimes through universal jurisdiction, which was implemented in a qualified way when they implemented the statute of the International Criminal Court. South Africa has this possibility as well. It exists. And it's very interesting to see whether some of your perpetrators in the current Ukrainian-Russian conflict may also end up around here and be prosecuted. And Africa may also wish to consider how to push forward mechanisms such as the Syrian mechanism, the one in Geneva that assembles information on war crimes and crimes against humanity, so that if there are these decentralized prosecutions, that one can actually have the access to the evidence and so on. And it's an opportunity to improve the relationship with the International Criminal Court. I have several other thoughts, but I think this is enough for now. But do not underestimate the value of decentralized enforcement. We're overemphasizing the Security Council and the UN, whereas we do have instruments on a regional level that needs to be strengthened, but we must make sure that what we have on paper also works. And that is all that I'll say for now.
Thank you very much, Erica. I think that's very, very great opening for us in terms of setting the stage. I take very seriously your invitation for us to think about an international legal order that is less centralized, so perhaps a bit decentralized, that allows, for example, regional arrangements like the African Union to work, that allows individual states to decide in their own region to take actions like countermeasures and so on. So I like those points. Let me go to Mohammed now, because of course, Mohammed is going to intervene and bring additional points, and I'll go to Phoebe, and hopefully at that point, we'll start to get a theme, we'll identify some themes and move forward on those themes. Mohammed? On the same question, basically, as a general matter, what do you think are the key international legal questions that arise for Africa from the context of this particular Ukraine situation?
Thank you very much, Charles. So first, as a general matter, I think the conflict in Ukraine is what you would call an easy case for international lawyers. There are very clear and really incontrovertible grave breaches of international law, whether it's Article 2.4 of the UN Charter that constitutes an act of aggression and potentially raising individual criminal responsibility for a crime of aggression. There's also several breaches of the prohibition on intervention in the internal affairs of states that Russia has been perpetrating for several years, particularly in eastern Ukraine, by funding, training, and arming separatist groups. There's also a breach of the prohibition on intervention by recognizing breakaway regions within Ukraine, and of course several very serious violations of international human rights law and international humanitarian law in the conduct of the conflict. And so, at least from a legal perspective, I found that the conflict in Ukraine does not raise difficult legal questions simply because it is such a clear and obvious, really indefensible breach of international law on the part of the Russian Federation. Now, and building on that, I don't think that, at least on those questions, they raise specific issues for Africa. African countries, as members of the United Nations, as members of the international community, are deeply committed to these rules, whether it's the prohibition on the use of force or the prohibition of intervention or the protection of civilians during armed conflict. So if anything, I would say that the international reaction to the breaches by the Russian Federation, which serves to reaffirm many of these principles, is actually a positive for the African continent. The only note I would say is that I'm always a little cautious of speaking of Africa as though it were some unified single monolith. And I think we have to be a little careful with this. Africa is, it's a very large continent with very diverse interests. First, in terms of its subregions, whether it's northwest, south, or central or eastern Africa, but also individual countries have very diverse relationships, including with the belligerents in this conflict and their allies. And so often, and I speak here as somebody who has many years of diplomatic experience at the United Nations, the African quote-unquote common position is often just the lowest common denominator that you can articulate between these very diverse positions. So I'm always very cautious in sort of trying to figure out what are the implications, quote unquote, for Africa, because often it's hard to frame the issue that way, but rather the question is how specific countries, or particularly pivotal states within Africa, because if you look at the continent, you have major players in each of the regions that often influence how the continental position is articulated. Final point on Erica's point about countermeasures, I would say that maybe Africa is a little, again, with the caveat that it's difficult to develop a single position, but there's always a sense of caution and maybe trepidation with the practice of countermeasures, because often Africa is on the receiving end of those countermeasures. We rarely have the wherewithal or the capacity to engage in effective countermeasures, particularly against powers as large and influential as the Russian Federation or other countries in the international system. So I do not expect that what the European Union or the United States are engaging in response to the Russian aggression against Ukraine is going to receive much support from Africa, because it sets a precedent that can very well in the future be used against some African governments. So I'll stop here, Charles, and hand over the floor to you.
Fantastic. Thank you so very much, Mohammed. I think those are valuable contributions as well. I guess a couple of key takeaways from what you said before I get to Phoebe. I guess one element is to say the Ukraine situation in many ways is an easy case. Mm-hmm. So I guess one of the questions that I'll be inviting Phoebe to comment on is if she also agrees with that. We definitely see international law at work from many perspectives, whether it's in the National Court of Justice or the National Criminal Court, whether it's the Security Council in the General Assembly, whether it's the Human Rights Council in Geneva, and so on. So in many respects, the response, as you say, reaffirms the core principles to which African states are committed. And I think the Kenyan PR's statement, the permanent representative in New York, really captured the moment and the mood, not just for Africa, but for the international legal community as a whole. That's one aspect. But then, of course, there's a second point that you made, which is a key takeaway, this idea that we don't think of Africa. When you say Africa, you got to be cautious, because within Africa, there's a lot of diversity of views, diversity of interests, right? And size of countries and influence and so on. So those are two key takeaways. I'll come back, I flag them because I want to come back to some of the themes that they generate. But Phoebe, you've been very patient, so I turn it over to you at this point.
Thanks, Charles, and thanks for the earlier generous introduction. The nice thing coming last after the panelists is there's not much to say other than to agree with both Erica about the need for more decentralized sanctions, and also agree with Mohammed that ultimately this is a very easy case. And in a way, hard cases make good law. In terms of charter norms, rules of international law, custom international law norms, this is as clear as daylight. But it's also shown spotlight on what I think is of interest to African states in terms of a perception that's been there for quite some time, that international law is always subordinate to considerations of ultimate power. And in a continent that's always marginalized, there's not been much room to exercise that power in disregard of rules of international law. So in a sense, the reaction, is Ukraine an aberration, or is it a continuum of great powers' disregard of international law? So much spotlight has been shown on it. And in a way, the conversation that's been around proceeds on the basis what Klaus said earlier, that Ukraine and the invasion of Ukraine and the disregard of the most fundamental norms is actually a threat to a world-based order, rule-based international order. But I wonder whether that rule-based international order has always been the case. I mean, the story of the Charter for the last 75 years, yes, this is probably the most blatant disregard, but I think that disregard has always been there. And so in one sense, I'm not saying very much, but I'm just saying that it quite clearly indicates that international law works best when there's a reasonable balance between regard for the law and great power interests. Mm-hmm. And I think what has been eroding over the years, starting with Iraq, with Syria, is an erosion of that balance. Ukraine just shines a spotlight on it. There've been, serious violations. You can talk of Yemen and other countries. And so I'm a bit skeptical of the view that Russia threatens the world-based order. It does. But in a sense, what we are seeing, and this is why, perhaps, I don't know, it's very difficult. And Mohammed made the point that the response of African countries is not, Africa is not a country. I think there's a book with that title. It's not monolithic. There are a variety of interests. But maybe there's also a subtext of African states feeling that they've always been marginalized, that they are not just going to vote in the interest of United States or great power interests without asking some searching questions, why they don't get the same treatment, or when issues of concern to them surface at the United Nations. So I think in a way it's as such that we need to have a conversation. If Ukraine is not an aberration, then what is the takeaway from it about how to recalibrate the international system to have a reasonably fine balance between great power concerns and international law? Because that's what the Charter was about. That's what the Security Council, that's what the veto is all about. I don't think there was ever any intention that international law was going to be enforced until heavens fall. After all, we have the veto. And not only do we have the veto, we have the fact that member states can actually use the veto in their own interests. And so in a sense, it's a room for that conversation around that balance. And where do we go from here? I don't know. Maybe we'll have an occasion to talk about implications within the Security Council system and others. But also, can I go on a bit?
Well, you may, Phoebe, but what I was going to do, if it would be okay with, is actually pick up on a couple of the important threads that you've added to the discussion and invite, first of all, a reaction from Mohammed and Erica, and then pick up on some of the substantive points, underline the comments, and the references have been made by both you and Erica, and in fact, Mohammed, all of you, to the role of the Security Council. So for example, so I said, would that be okay for you as a way of proceeding so we can actually build on some of the points?
That's fine. I can come back on other things later. That's fine. No problem.
Fantastic. Okay. So let's do it this way then. At this point, I think we've heard the view from Erica concerning the need for decentralization of international law, that in fact, this may be an opportunity for African states to think about what they have in their own toolkit, so to speak, whether as individual states or within the framework of a regional organization like the African Union, and to think about their engagement with international law and questions of relevance for them through those kinds of prisms, including obviously the use, for example, if possible, the issue of countermeasures. On the other hand, we heard from Mohammed, who says, hang on a second, Africa is not a country. Right, that's true. And you're right, there's a book, Africa is not a country. But on top of that, more substantively, this idea that what is going on here, in a sense, is an easy case, right? This is not a difficult case. This is not a difficult case where international lawyers are fighting over the interpretation of the event. We see a clear path because we can agree what is going on is a clear violation of the Charter itself. Oh, I'm sorry, I don't know whether we've lost Erica. Erica, are you there? You're there. Okay. Oh, fantastic. Okay. And then so that was that point by Mohammed. So let me just pause actually before I go any further in terms of summarizing essential issues. Mohammed, did you want to react and first to what Phoebe has shared and Erica's points of view? There's anything you wanted to develop?
Sure. So I'd like to pick up on something that Phoebe referred to, which is the concept of the rules-based international order. let me say this. International law, at least in my perspective, is ultimately based on the balance of power. And international law is not designed to operate, at least in my view, in opposition to the balance of power. And what I mean by that is the following. International law and international institutions operate at their best when there are two conditions that are satisfied. The first is when there is a balance of power and a balance of interests, particularly between the greatest and most powerful actors in the international system. And second, when the international system shares a set of common norms and common assumptions about legitimate behavior in the international system. What we have been witnessing, and I think this is something that Phoebe referred to, over the past decades is an erosion of both those elements. And I think it's essential for us as international lawyers to be cognizant of the political environment within which international law and international institutions operate. And specifically, what we've been seeing over the past few decades is that the so-called rules-based international order has been challenged both from within and without. What I mean by saying it's been challenged from within is that many of the countries that have been the so-called leaders of the system have been taking steps that undermine trust and confidence in the system. Some examples of this include US behavior in conflicts such as Iraq and Afghanistan, the so-called war on terror, the so-called drone war that has been going on endlessly, but also US behavior in the context of international economic law, its behavior in the WTO relating to the dispute settlement body. At the same time, so this is what I mean by it's from within, the main sponsors of the system, particularly the United States, has been invoking its so-called exceptionalism to essentially erode many of the norms underlying the system. But also, you've had a fundamental shift in the balance of power. The center of gravity in world politics has been moving eastwards. It's now probably centered around the Asia-Pacific or the Indo-Pacific Rim. Now, these are fundamental changes in the balance of power, and what we're seeing today is a symptom of that change of power. That there are powerful players that are pushing back against this so-called rules-based international order, often in violation of international law, whether it's China and certain activities in the South China Sea or Russia in Ukraine and so on and so forth. So I guess what I'm trying to do is to place the Ukraine conflict in the broader political context in which it is occurring and to highlight that we are in a moment of transition and international law will invariably be affected by this moment of transition. We will see institutions under pressure and under stress, norms of international law that are placed under stress, and there will be calls to revisit some of these norms. And so it perhaps is incumbent on regions such as Africa to develop a vision for what a new world order is going to look like, because it's happening. The only thing is we don't know exactly what it will look like because we are in a moment of transition to a very different international system. And so I guess I'm just sort of developing the theme brought forward by Phoebe that in many instances, Africa's reaction to this conflict can only be viewed through that lens, that African countries realize that there are fundamental shifts that are occurring and that they're basically hedging their bets. I shouldn't say they, we are hedging our bets and trying to balance because the future is uncertain. Yeah, so I'll stop there.
Thank you very much, Mohammed. Unfortunately, it looks like we lost Erica. I hope, Erica, you were able to get back on. Claire, perhaps you can resend the link or something, and let's see if we can get her back into the room. I think Phoebe.
Can you hear me, Charles?
Oh, we can hear you perfectly. Okay, so you're there. Fantastic, fantastic. Welcome back.
Thanks. So what have I missed?
So I had just invited Erica a reaction from Mohammed to Phoebe's points concerning what she really was situating as, she is first of all agreeing, I thought, with Mohammed's point of departure, that we do have, that Ukraine is an easy case. But then raise the second point, which is the point that Mohammed was reacting to, concerning the circumstances under which international law would work, which essentially brings up the element of the relationship between the law and great power interests. And Mohammed was just reacting to that particular aspect of our remarks. So I was going to invite you to react to this particular issue, and I want to direct towards some of the elements, especially, for example, the role of the Security Council in the wider context of this idea that there's a shift happening in terms of power balance in the world. But Erica, if you want to comment.
Okay, I'm commenting, and thereafter I'll try and switch. I'm on my phone now. I hope, as long as you can hear me well, that's fine. As far as the Security Council is concerned, I want to make 2 points. The first is, we should not forget that despite all the problems that we're seeing and the abuse by major powers, you know, across the board, and where they do not live up to their duty, there is still, the United Nations is still providing peacekeeping operations and authorizing these operations in Africa. So at least on that level, we have very important peace enforcement missions in the DRC and, you know, in that region. So that's not enough to be satisfied with, but despite all the problems, it is not as entirely frozen, the Council, as it was in the first Cold War, if I can call it that. At least there are some robust peacekeeping operations that Africa also benefit from within the Council. And one should also, when it comes to the veto, one should not, there are 2 things. One should not overestimate the consequences of abolishing the veto. In Africa, in the African Union's Peace and Security Council, there is not a veto. You can have a majority decision on important questions, but we know in practice that de facto unanimity is very important. It's the same in the EU. Once again, meaning you get, you know, to the lowest common denominator. So the fact that you merely abolish the veto doesn't mean that suddenly states are, everything is going to get better. And we saw that in Burundi, for example, you know, when there was this, the fears of genocide in Burundi 2015-16, Article 4H of the Constitutive Act was almost triggered, but then in the end, there was not enough consensus and African states backed down. Meaning that even without a veto, hegemons, also the regional hegemons and the large powers have their fingers everywhere in the pie. They have their allies. Things are very difficult. It's very difficult to take decisions. And all these regions have their economic and social differences. There's no just one Europe or one Africa, as has been mentioned. My point being, we have a problem with a veto, but I'm very concerned about the fact that people think that once the veto is gone, you know, that then states, everything will be decided the way we want it to be decided. We may not get what we wish for. And also, there is justified fear about abuse of military mandates and other mandates. The Libyan trauma, I think for many in Africa, is still very, very alive. The abuse of that mandate that resulted in regime change, destroyed a country, destabilized the region, kills hundreds and thousands, resulting from that ill-advised intervention and regime change, has made it African countries very reluctant, is my sense, and perhaps Phoebe and Mohammed have views on this, to vote for these type of extensive mandates. I can very well imagine that that also affects actions within the AU as well. So there's also this justified fear of mandate abuse, which makes countries very reluctant to vote in favor of any extensive Security Council measure. So on the one hand, states cannot hide behind the major powers anymore. Like in the GA, we've now also seen there's no veto in the General Assembly, and we saw who voted with Russia. We saw who abstained. Okay, so now with a veto, little states and other cronies can hide behind the veto and say, well, you know, it's the big states abusing. But once the veto is gone, first of all, their bluff is called. They have to show their colors. Second of all, we see that it's not so easy. The power relations take their toll even in the absence of a veto. And thirdly and finally, do not forget that there can be very good reason not to vote in favor of an extensive mandate because of the abuse and the consequences of that abuse, which, you know, is atrocious and is not getting enough attention. I hope you could hear me clearly.
Yes, we could. Thank you so very much.
Thank you.
Loud and clear, Erica. So a couple of themes that have come out that I'm going to turn it over to Phoebe to respond. The first theme concerns this idea that international law and international relations may be changing because of some realignment of the great powers. So power is shifting in a particular direction, perhaps. I think Mohammed's suggestion was we see power going in a sense towards the Asian region. So there's that one aspect. And there's a second aspect that concerns the way African states are reacting in this moment to international challenges like the conflict in Ukraine, but perhaps in a wider timeline, thinking about previous experiences. I think Erica mentioned Libya, for example. We could talk about Iraq. We could talk about several other situations where the great power that violated the norms of international law is not the great power that we're talking about now. It's other great powers. So essentially, the idea that self-help, when it's convenient for me, I'll do it. I think Mohammed talked about the US. We could talk about the UK examples. We could talk about many other examples. If you think about the Chagos issue in terms of the UK and this disrespect for international law, it's very clear where the UK stands. Essentially, again, what I guess where the key sponsors, as Mohammed puts them, they are now playing in that sandbox of disruption themselves. So anyway, on those two themes, you could then overlay the Security Council reform and perhaps wider and deeper structural reforms of the international legal order. Phoebe, you've been very patient. Please weigh in. You have to unmute.
Just going to say that I agreed with what Mohammed said, especially on the question of states realigning themselves east, because, and just one specific comment on that, if you see about Russia's long support for Assad and the fact that a conflict that was perhaps going to end quickly has dragged on for more than 10 years and Assad is victorious. If you're a dictator worried about your next move, I would say, take your bet with the Russians. You know, these guys are loyal. They'll stick with you. Forget the Americans, forget the UK. You look at what happened to Mubarak. These are fickle. And I'm not saying, I don't know whether that was why they voted. But I think that there is a sense in which states are perhaps thinking also in terms of their own long-term interests. But I see much more specifically that this is an opportunity for reform. The question of Security Council reform has been on the agenda and talked about for more than 40 years. So maybe for African states, this is a good opportunity to, as it were, really agitate for questions of inclusion and questions of, and support any reform initiative, precisely because there's a stalemate. Their permanent members are unable to do anything. And now they probably realize that the Security Council in its present form is not even going to serve their own geopolitical interests. So I think it's time for African states really to perhaps even take leadership on how this is taken forward. I'm less skeptical about, I don't think on the table is necessarily the question of the abandonment of the veto altogether, because the veto will still be useful where great power interests align. But what if they don't, and say there is an unreasonable use of the veto, which is blocking a decision which may be in the interest of the common good? So there are suggestions now on the table which are being put forward. One is that the possibility of the GA being able, or at least 2/3 of its members or 2/3 of the population in particular instances, being able to override the veto power. Because at the moment, we are at a stalemate. We have a council that's unable to act in the interest of peace. And that may be a decision that would give African states a chance to have a more inclusive, a more legitimate decision-making. So questions of reform we'll also come in with questions of who is in it, maybe, how are we going to make these decisions? Can we insist on working with an institution that represents the geopolitical interests of 1945 and not the power structures of today or the great power? So I see it that, you know, the whole question of reform, whichever direction it goes, whether it's supporting an opportunity to override the veto, or even the more modest proposals such as that proposed by Liechtenstein, which would require the P5 to explain their veto, any attempt to use the veto before the General Assembly. I'm not sure where that would go in preventing the present crisis. But certainly, given that the other four, or maybe not the other four, at least certainly maybe 3 states within the P5 would be very interested in a way out of the present stalemate, it's an opportunity for African states to see the new realignment as one in which, in some form, they are included in the decision-making. Because don't forget, I think on one estimate, more than 80% of the Security Council's time is taken with decisions on Africa in relation to an organ in which they have no veto or representation. So even some of those confrontational relationships between the ICC, as we all know, and Africa, are all about exclusion and about who makes the decisions that affect them. So the whole question of inclusion in the decision-making process is one that I think should now be very carefully considered, and which the AU as a collectivity of African states should agitate for in any reformed council. I don't think doing away with the veto will necessarily mean expansive mandates. In a way, it may help in a situation such as Libya, because Erica, if I remember correctly, the African Union was actually debating what to do in Libya on the eve of the invasion. And I think they'd come up with a plan which would have given Gaddafi a way out, either into exile or some other process where he'd give up power. But they were overridden. In fact, they were not even given a chance to implement that, because by bizarre logic, it was seen that they were all co-opted by Gaddafi and could not be trusted to be neutral. Never mind the very complicated relationship, say, between countries such as the UK and the Gaddafi regime. But essentially, the African voice didn't matter. Whether they had a plan which would have taken Libya out of the current crisis was never considered. A pathway which would have enabled Gaddafi to go into exile and perhaps not be subject to the ICC regime. So anyway, I would say that I see it as an opportunity for reform, and a reform in which Africa should absolutely insist on having a voice so that decisions are far more legitimate and that aligns with the political realities of 2020 and not 1945.
Thank you very much, Phoebe. I think really, again, interesting points. So a couple of themes, and I'm going to build on this because I want to move the conversation a little bit forward now. So one aspect is the idea that this may be an opportunity for reform of the Security Council, and definitely African states have taken a position on that. So this common African position, it may be the lowest common denominator that can be agreed, but they do have a position, a long-standing position with the Zuwini consensus that they've been advancing at the international level, but without much success. And so in a way, then it's generated perhaps not just that proposal, but all the multiple proposals, which again have to be blessed by the P5. That's been the fundamental sticking point. You said 40 years, right? That's been this fundamental sticking point over all these years about effectively playing around the edges, right? So you say, well, can you promise not to use the veto, for example? So the reason why I'm raising that, I'm making that point, picking up on that point, Phoebe, with the ACT initiative and so on, is one might argue, or some might argue, that actually playing around the edges allows for the exceptionalism to continue. Let's go for full-throated reform and have reform now or not at all, with all the caveats that Erica was introducing about be careful what you wish for. The fact that you get a veto power does not necessarily mean the problems are solved. But I think what seems to be coming out, and I'll be very curious what Mohammed thinks of this, is the idea that some reform is necessary. Definitely within the UN security architecture, we don't see the type of action that we expect when you have threats to international peace and security. This is a theme that seems to be standing out quite a bit in all of your remarks. The second point, though, is African states are now doing a recalculation. They're calculating when they want to act, when they want to join countermeasures, because they fear of the abuse. And your example of Libya is a perfect example of a situation where you had a regional body that's trying to take decisions that were more long-term, arguably more holistic, but then the P5 wanted to bomb, or at least P3 wanted to bomb, right? So we got the bombs instead, and you have a failed state in Libya. So in a sense, the skepticism towards international law, my interest plus could this be used against me in the future, is part of the trend, if you will, that we see. So let me ask, so based on those two themes, if you would agree with those two themes, do you think that there's an opportunity now that if the African states don't take, they would lose that opportunity in terms of leadership towards making some of those changes, keeping in mind that they also have now deep interest with, for example, China in Africa? We haven't talked about China. It's another great power that's really flexing its muscle on the continent right now on all kinds of levels, political, military, legal even. Erica, you want to weigh in? I want to give Mohammed a chance to respond.
Let's let Mohammed go first, and then I'll jump in.
Yeah, Mohammed?
Oh, well, thank you. I don't know if this is going to be a popular opinion, but I think any talk about UN Security Council reform is really a waste of time. And I don't mean a waste of time on this panel at all. I just mean that there's no such thing.
Right? I agree.
Okay, great. So I can stop there. But so, I mean, come on. UN Security Council reform means three things: reform of voting, reform of membership, reform of operating procedures. Those are the three issues that are being discussed in what is called the Open-Ended Working Group on Security Council Reform at the General Assembly. There has been zero progress on any of those issues, and there will be zero progress on any of those issues, and that's why it's called an open-ended working group, because it has no end. So if we take any of those issues, let's start with membership. The primary candidates to join the Security Council are Germany and Japan. And the United States actually just endorsed Japan as an additional permanent member of the Security Council. What does that mean for the global balance of power? It basically means 2 additional US allies joining the Security Council. Why would China and Russia ever accept that? It's unthinkable that they're going to accept that. Other countries that have been touted as possible permanent members are India. Again, India is a country that has been successful in balancing its political positions between its traditional adversary, China, on one hand, and its traditional ally, Russia, and its relationship with the West. And so it's uncertain how India would act as a UN Security Council member. Another possible country is Brazil. Under Bolsonaro, Brazil is much closer to the United States. So I think the core of it is this: Security Council enlargement with adding new permanent members is not going to happen, ever. Second, Security Council reform with the veto, any kind of change in the core of the veto is never going to happen because it requires the consent of the veto-wielding countries. And none of them, whether it's the United States, the Russians, or the Chinese, because they are the countries that use the veto the most, and they're the most ardent supporters of the veto, they're never going to give up that power. Now, finally, on the Ezelweni consensus. So I would actually call Ezelweni the highest common denominator as opposed to the lowest common denominator. And let's be very honest about what Ezelweni is. So the Ezelweni consensus emerged out of a debate within Africa as to one of two options. Should Africa identify 1 or 2 countries that should be African candidates for permanent membership or not? Or should the decision be left to the UN General Assembly to pick African members? And because Africa could not agree on how this process should be managed, we ultimately ended up with the highest possible request. Africa is requiring 5 seats, 2 of which are permanent with the veto and 3 which are non-permanent. Again, it's impossible. This is political posturing at its best or at its worst, depending on how you look at it. And so, we can talk about it. One last thought. I know I've gone over time, but just one last thought. This concept of legitimacy. The Security Council is not designed to be, quote unquote, legitimate. It's a great power concert. It's a reflection of who has nuclear weapons, who has the biggest naval fleets, who has the biggest ability to inflict the greatest violence. This is the reality of the world. That's the reality of world politics. With all due respect, none of our countries in Africa has that capability. It's not designed, again, it's not designed to be legitimate. It's not a law enforcement body. It's not designed to be a force for good per se. It is a mirror on which the global balance of power is reflected, and it is designed to operate much closer to the 1815 concert of Europe than it is supposed to operate as a global law enforcement. And having read Professor de Wet's books, I'm certain that maybe she may counter or push back on that. But anyway, yeah, right, go ahead.
Mohammed, you may be surprised that with most things you say, I actually, as a matter of pragmatism and reality, absolutely agree. I do, however, Phoebe raised a very important point that Africa should keep this debate on the agenda. So in principle, I agree. From as far as the principal perspective is concerned, I agree with the line that Phoebe wants to take, and you probably don't disagree with that either. But my concern is, for all the reasons you've mentioned, it's not going to happen. My second concern is, just if for a moment we assume that there is this breathing space, and Africa can agree on which African countries should go in to the Security Council, I'm afraid that the Chinese will have a lot to say about that, just given the hold that China in particular, Russia as well, but increasingly China, have economically over so many countries. Make no mistake, the South African government, which, given South Africa's own history, its own aggression in the region, and then making this U-turn in 1994, committing itself so progressively to international law, the fact that they didn't come out and say this was an act of aggression had a lot to do with economic hold, old political alliances as well, but economic hold that Russia and China and the BRICS nations have over that country. So all of that will play into, just assume there is reform, and we have a window of opportunity for doing it. That's why I say, don't think that reform is necessarily going to go where we want it to go. The Chinese are on the rise, and I have my issues with the big three, but I hold my heart if I think what's going to happen, if I see what China is doing to the African continent economically, to the people, to the resources, where that will lead, if they ultimately de facto, as the major power over about the next 30, 40 years, decide behind the scenes which African countries go into the Security Council. There may come a day when we wish we never tried to reform. But I am conflicted, because I think in principle, Phoebe has a strong case that we have to remind, the powers that be, that we are being underrepresented as a continent, and all these peacekeeping missions and so on. As you say, it's the decisions directly affect the continent. And then a final point, what I do think, okay, so assuming we're not getting a new treaty, a revised treaty, law can always develop through practice, and it has developed through practice. And I mean, this notion of the coalitions of the willing and able is something that has developed through practice. Theoretically speaking, the General Assembly could become more aggressive and try to take more decisions. And initially, some will argue that it's illegal, but if there's enough support and if it keeps on doing it, it may incrementally, do more. One can also try that avenue, but just given that it's such a large body, getting any sort of common denominator out of such a body is very difficult. It was one thing to get states to condemn the awful aggression, but moving to the next phase, what do you do now? Good luck. I mean, even in the conflict is 500 kilometers from where I live. So it's very, very palpable here. But even now, the consensus within Europe is starting not to collapse, but it's not as strong when it comes to the countermeasures. We're feeling the inflation. We're feeling the impact of an oil embargo, of a gas embargo. You know, it's come in the next 3 months, public opinion will be more concerned with how are we getting through the winter than being solidaire. That's unfortunately the reality of life. And this is the EU with only 27 members. What do you do with a General Assembly with 194 members? So good luck. Therefore, Phoebe, I think that one still has to fight the fight, but we shouldn't spill all our energy on that. We should be pragmatic enough to say, how can we make the council in its very defect form still work just a little bit, at least for Africa? And how can we make the AU stronger? What aspects of the AU can we push forward? Article 4H, even if we don't want to apply countermeasures for the very valid reasons, rethink our intense animosity towards the idea, which may be a bit too categorical. What instruments of international law is there to become more self-sufficient through a regional organization? ECOWAS, by and large, works relatively well. Of all these different units, it seems to me to be the one that gets on with it the best. So don't put all our eggs and energy and despair into the reform basket, but deal with the realities in a more diversified way. You're muted, Charles.
Charles, you're muted.
Okay. Can you hear me now?
Yes.
Fabulous. Okay, I don't know what happened there. I was just saying this is a fascinating conversation. I think it's going in interesting directions as well. But I'm looking at the time, and all of a sudden the time is really going very fast. And I did promise the audience that I'm going to come to them. So I'm going to invite any questions. I just looked at the chat, and there are no questions in the chat at the moment. That does not, of course, mean that folks don't have thoughts, comments, questions. So I'm going to invite the audience to think about their questions. If they want to ask for the floor, to feel free to do so. So I can, of course, you can ask a question specifically to someone, or you can ask to the whole panel, and they will do their best to address the questions as quickly as possible, so we can get in as many questions. I do want to flag one point that I think is very interesting that connects a lot of these threads. In a sense, it's the double standards in the response that we see. But if you think about the legal aspects of all of this in terms of multilateral institutions and so on, you think about individual states and their actions, if you think about countermeasures against Russia, Russian Federation, and so on. And so those double standards seem to come up quite a bit. We've seen them when it comes to solidarity expressed by European states towards Ukrainian refugees. Papers have been issued to individuals who are fleeing conflict, and nobody's questioning that these are fantastic initiatives. Everybody's heart bleed for those individuals who find themselves in these very difficult positions, but they do sit in that wider context of why are you not reacting in a particular way also to other conflicts? And that's some kind of issue that's, if you will, sits in the backdrop, and you hear about double standards in responses as well. So I do want to bring that point in, and I don't know whether any of you want to react at this stage, or maybe Phoebe, because Phoebe, you've been I think Erica responded to you in a way, and of course now you have a chance to respond while our colleagues think about questions. Otherwise, I have more questions for all of you.
Do you want me to respond to the double standard question, or just generally?
Double standard, if you like. Yeah, maybe develop the double standard if you agree or disagree.
I mean, again, I agree, and it's very fascinating to see, both in terms of the, Ukraine was almost treated as exceptional, absolutely different, and not even within a context, as which I started with earlier, where other great powers have also disregarded rules of international law and the speed with which it was necessary to take action. In a sense, we all saw this coming. You can say this with hindsight in terms of Russia's own engagement in Syria, and no response. No concerted effort, no consideration. That was 11 years ago. It was essentially just allowed to go by the by. But in a sense, these double standards, the lack of consistent application of rules, and the lack of, consistent application of principles of humanity, in itself very quickly undermines any claims to solidarity. Maybe that partly, I don't know, claims the African vote, but it also undermines the rule-based international order, which we were talking about already, because ultimately all these institutions, whether it's the ICC, whether it's basis of universal jurisdiction, or whether there is the need for a bespoke court to try aggression in Ukraine, I think are viewed with profound skepticism, because some of the various states that are advocating a very clear and organized framework of accountability have themselves been opposed to the court, the ICC, have themselves been only keen that the ICC be used by African states. So in a sense, it provided an opportunity to reinforce the ICC as a universal forum for criminal accountability. But the moment you get to a European problem, there's almost an attempt to create a separate institution. I think the double standards, I have to say, became very, very apparent in the push quite early on to create a bespoke special tribunal for aggression in relation to Ukraine. And there were no considerations whether was this going to be a tribunal with a standing mandate to try all cases of aggression, or is it just going to look at this one particular case? And ironically, by the very states that have made it very difficult for the ICC's jurisdiction on aggression to be fully operational, who've been opposed to it and who've not signed up to it. So it's very difficult, because if you're going to have a rule-based order, then you have to be seen to be applying the rules at least reasonably consistently. And that in itself, I agree that, sometimes law gives way to considerations of ultimate power, but the opportunism that has been so apparent in some of the responses to Ukraine have just been appalling, I think.
So let me pick up on that thread, Phoebe, because I see a connection between the point, the specific example that you are raising now concerning the idea of a special tribunal to prosecute the crime of aggression, with an earlier point made by Mohammed concerning the shift that we see in the international legal order, but a shift that's taking place in the wider context of the big states that are traditionally the sponsors and supporters of international law, incrementally chipping away at that system because of the self-help, right? So it's easy for me when it's the ICC debating whether to have jurisdiction over the crime of aggression in one format, create an exception for myself there, and just a few years later, literally just before the ink is even dry on the paper, now I have a problem, and I turn around and it's like, oh, well, create a special tribunal. And I found that debate very interesting and in some respects quite curious, because I wondered, given that history of their own engagement as a matter of convenience on those kinds of questions, this may be the time for well-meaning international lawyers to call them bluff. Why would you create a special tribunal for the crime of aggression as opposed to move for an amendment of the Rome Statute system so that the court that already has jurisdiction over the situation, over which, in respect of which there's political support, at least 40 states have supported a referral to the court. That's a court that apparently didn't have any money before all of a sudden it's been offered all kinds of money, right? Raising again all kinds of questions, because again, these have been the perennial issues, the zero growth budget policy towards the ICC, right? The same states that are now able to find the resources, they didn't have the resources before. So in a sense, it's the point from Mohammed that international law does exist in a political framework. So while you may be talking about a treaty, the very framework itself may have that lopside, may have that imbalance. So let me invite comments from Mohammed on those aspects or other aspects that you see as relevant. And I'm going to look at the chat because I think while I was speaking, I saw someone ask a question. Okay. And this question, I think maybe is the first question. So I'm going to actually just pose it now, if that would be okay to all of you. And the question is from Tan Moy, who says, how long would it take for the world, minus the 5, to finally accept the question of equality? Why not just make the General Assembly a democratic forum rather than picking some based on some discrete criteria and make the forum more powerful by giving it more teeth to act? What is stopping us? That's a very good question, right? It goes to the heart of the problem that we're talking about. So maybe Mohammed, because I was going to invite you to react, and then Erica, I'll come to you next. Maybe you can also address that element as well.
Yeah, thank you, Charles. So I guess I can engage with the question from the audience first. I mean, really, honestly, there's no such thing as equality. There is the concept of sovereign equality, Article 2, Paragraph 1 of the UN Charter, but that just means that all states have equal, what James Crawford called plenary powers in the sense of like basic rights and obligations and prerogatives that flow from the concept of statehood. So in that sense, all states are juridically equal, but we would be naive. And I mean, there's 4 Africans on the screen here. We would be very naive to assume that there is such a thing as actual, or let's call it, there's de jure equality, but we don't have de facto equality in the world. And that's pursuing that is impossible. And you know what? That's not only international law, that's also the fact of domestic law. Power matters in domestic legal systems. The powerful and the rich are more capable of getting away with breaches of the law, just as powerful and the rich are able to get away with violations of the law internationally. That's just the nature of life, I suppose. But I want to go back to Phoebe's point and Charles's question about the special tribunals. And I agree entirely. The sense of skepticism and really the sense of, are you so hypocritical that you're actually talking about a special tribunal for aggression for Russia so close after you essentially torpedoed the jurisdiction of the ICC over aggression? But also, to me, this is what here in the US they call lawfare of the worst kind, because it has no sense of policy implications. And let me just point out to 2 implications. So let's assume a bunch of countries get together and they create some tribunal and they issue an arrest warrant for the president of the Russian Federation. How does that impact world security? What do you expect Russia's reaction is going to be? Is Russia sort of going to concede and is going to sort of pliantly comply to these demands from Western countries? The end result, probably from a policy perspective, would be more violent reactions from a great power that has the largest nuclear arsenal in the world. So that's not a very smart way of trying to increase the chances of world public order. But second, and this is why it's a really stupid idea from a policy perspective, because in the not too distant future, I'm certain that Western powers are going to commit acts of aggression. How would the rest of the world, you know what? I bet the Chinese and the Russians are going to establish their own special tribunal and they're going to issue their own arrest warrants. And many countries may find themselves compelled to comply with such arrest warrants. And so, I mean, it's such ideas that are so short-sighted from a policy perspective and so hypocritical, as Phoebe was saying, from a legal perspective, are really just really frustrating, I suppose, is a good way to put it.
Thank you very much, Mohammed. Let me just put a point here, Erica, I'm call on you, because so in fact, the very idea itself assumes, and this is your point, Mohammed, but maybe slightly differently, that those Western powers are not aware of those implications, right? That they will actually go along now to set up a special tribunal, as opposed to having an institution that has more global buy-in. It's definitely not universal, but accepted by 123 states parties at the moment in respect of at least the 3 core crimes. The other crimes, right, we'll put it kind of like a separate basket. For the most important, the supreme international crime, as they described it at Nuremberg, for the crime of aggression, which I know has a lesser number of parties because of this jurisdictional regime, in part, probably. So anyway, Erica, your reactions to this. And again, I invite the audience if there are any more questions for the chat or directly.
Thank you, Charles. And I will also, in my answer, try to respond to Christian Pippan, my colleague's question in part, but as I see it. Well, first of all, I agree with everything Mohammed has said. And just when it comes to the issue of the nuclear capacity also of Russia, I think in all this immense hypocrisy and double standards that we've been discussing, this is, however, an elephant in the room that cannot be ignored. I mean, I personally would love to have seen a tribunal on the crime of aggression after the United States invasion of Iraq in 2003. I do not see how that could not be a crime of aggression. I was not popular for stating it at the time, but I've been contacted, and many of us have held that view for a very long time. And for some sort of tribunal, examining the abuse of the Olympia mandate and the fallout of that. Of course, it wasn't even discussed. That being said, and you can hear like my voice is rising, how it still upsets me. We are dealing with a nuclear threat here, which does add a somewhat different dimension to this, which doesn't justify the double standard, but which does justify a strong reaction. I just think we should not forget that. Mm-hmm. Also, what I'm always concerned about is when we are so concerned about the double standards is that we don't think about what can work. I just want to remind all of us, we can still prosecute individuals for the crimes against humanity and war crimes. Even though aggression is not on the table and so many energy is being pushed into that for the wrong reasons, think of what we can do. So there are things that can be done through the ICC, through complementarity, and also on occasion, it's not a brilliant solution, but on occasion through universal jurisdiction, the way it's now being done for some crimes committed in Afghanistan and Syria. And also in Africa, once again, we have to reassess, because our own double standards. And Christian, to your answer, I'm afraid many African countries are going for economic reasons, and because they are weak and financially dependent on Russia and China, that's the way that they will go. The vote in the General Assembly already exposes who goes where, and I'm very proud of many African countries who, despite being in dire straits, took the, in my view, the right decision and just called the wrongness out for what it was. But some of the more economically strong countries, what one would think, had some rather dubious positions. And I think that is partly, that's the way things seems to be going, at least for some countries. So that's why also China also not a democratic state, not interested at all in any form of democratic values, having such an hold over the continent. And on that level, within the continent, we should also call out things like, now in Southern Africa, again, there were elections in the region where, that were not held in a proper way, and the neighboring countries not calling that out, not following through in the case of Burundi when it was where the situation was very dire, not really acting against atrocities in the region. We have the Malabo Protocol, which is in many ways a bad document and has all sorts of problems, but where's that going? Has anybody ratified it? My concern is just that we are many decent people across the world are so upset with these double standards that once again we hide behind that. We are so fixated on the double standards of the very big and the very powerful that we forget to look in the mirror ourselves and try the few and fix the things that we can fix. We will not be able to fix all of those things, but we can look to our own region and our own sub-regions and call out the wrong for what it is, because there are things that we can do on the regional level, to address atrocities and so on.
Yeah.
Thank you.
Thank you very much. I think someone has their connection on. Okay, good. Thank you very much. So Phoebe wanted to react, and I just note, thank you very much, Erica, for your interventions and pointing out some of those aspects of, in a sense, what are the roles of African states in terms of some of these questions, especially those ones that are of regional character. But Erica, Phoebe, you wanted to respond, and I just want to draw your attention to a number of comments have been made also in the chat. So I like that Erica picked up on Christian's point. So maybe if there's anything else, Phoebe, that you want to address. And after this, I'm going to have to invite all of you to give your closing comments. So maybe Phoebe, you can react and then give your closing remarks while you're at it, because I do want to keep the panel on time, if that will be okay for you.
So I just wanted to respond very briefly to the comment in the chat, which essentially highlighted the question of inequality within the GA, and why not just have a more equal decision-making process where all states would have one vote within the General Assembly. And I think Mohammed has already responded to the question of the distinction between formal equality and the realities of equality. And I would just say there that actually equality within the international system, as within domestic law, as within family relationships, is a promise. And you just have to keep chipping at it. You may never reach that ideal, but you need to keep asserting it, to keep asking for recognition, and to keep reaffirming it. So I agree that the wholesale reform is not going to be possible for a whole lot of reasons, either in terms of, we've talked about Security Council reform or giving more power to the GA. But the ideal that we should aim for, a more equal world, a more legitimate decision-making process, is one that we shouldn't give away too easily. We need to reaffirm it and consistently assert it. So I think that's what I wanted to say in relation to the audience. I think the one other point you asked me to make my closing remarks, was just one thing, again, a follow on. On, yes, Erica's point, the elephant in the room is, of course, nuclear weapons. And it would be myopic, extremely naive to say that this is a situation like all the others. The difference is that we have an act of aggression by a state that possesses a large nuclear arsenal and has threatened to use them, and that the response has to be strong. But Erica, that's where, if the response has to be strong, perhaps this response has not been strong enough, because on one view, the failure to respond decisively is sending a message to everyone out there that the only way to protect yourself is to get nuclear weapons. Because remember, Ukraine, as part of the settlement deal when it became independent, gave up its nuclear arsenals. So any state now would say that you have to have your security in your own hands. And maybe the perverse effect of this is that it will lead to nuclear proliferation by states that may otherwise not have thought about it. Or you wanted to finish on time. I think the other thing which I will just throw it out there is, as a continent, both the founding principles of the OAU and AU has a commitment to the uti possidetis rule. And in some sense, the invasion of Ukraine is an attack on all those values of territorial integrity. And their argument that uti possidetis rule can in itself be a very unfair rule if there is no organized and clear framework for dealing with other principles that may make a boundary or may make a frontier or may make existence legitimate: historic ties, religious ties, ethnic ties. And so I just wonder whether, in fact, this is a call for an organization such as the OAU and AAU not to essentially just chant the mantra of a commitment to uti possidetis or territorial integrity without having an ongoing engagement about other concerns that have been swept under the carpet in the long period that this has been the founding principle. This is not a justification for what Russia did, but essentially that the whole ethnic dimension of engagement in Eastern Ukraine and Crimea means that chanting a mantra in itself will not sweep away the problems without concretely engaging with them.
Thank you very much, Phoebe. I think those are, again, very thoughtful interventions. And it's clear that already we've opened up a lot of discussions that we're not even able to pursue. But I'm hopeful that we'll get another opportunity with the later panels. And we'll talk about that maybe offline, because it may be worth having a continuation of the discussion with the same group of colleagues. But let me invite at this stage, Mohammed and Erica, if you had any last thoughts that you wanted to share from this conversation before we close off.
I have nothing to add. I concur with what Phoebe has said. Thanks.
Okay. Thank you, Erica. And Mohammed?
Well, I definitely concur with everything that Phoebe said. I think I just would like to engage with very briefly with two questions from the audience. The first question from, I believe, Christian, about the so-called dichotomy in the world. And here, I think, is where I feel very strongly as an African, and I think this is an African perspective in this sense. This idea that the world has become dichotomized between what Christian calls post-Westphalian liberal countries and authoritarian countries is such a Western construct. I don't think that the vast majority of African states are, I'm not going to speak on behalf of Africans per se, but I can say with some confidence that I don't think African states view the world as that. And in fact, if anything, it is specifically this narrative that is very popular right now in the Western media and in Western scholarship about, oh, this is democracies against an evil authoritarian power in Russia. I can tell you that the vast majority of African countries don't buy that narrative, including democratic countries in Africa, such as South Africa. Let me put it this way. The world's largest democracy, India, does not see the world in those terms. And so if anything, I actually feel that this narrative is very dangerous for world order and for the functioning of international law. This construction of the international system as though there's a bunch of Western liberal countries around the two shores of the Atlantic against the other, against a world that is either illiberal or authoritarian. That just essentially, this is it ultimately leads us, going back to something Erica said, to a second Cold War. And the vast majority of the world, or at least I can say that countries in Africa and probably many countries in Asia, do not share that perception of the world. Decisions are made not on the basis of regime type, but on the basis of material interests. Whether you have economic and political interests, whether you are in one way or another allied with the Russians or the Chinese or the Americans or the Europeans or what have you, but not through this lens of domestic regime type. One last thought on two questions about jus cogens. Again, international lawyers love jus cogens. I'm not one of those. I'm an international lawyer, but I'm not in love with jus cogens. But many international lawyers love jus cogens. Listen, jus cogens is a substantive principle that prohibits certain breaches of international law, but it does not have an enforcement element to it. You are not required to vote in a particular way in the General Assembly because of a breach of a jus cogens principle. You're not required. Jus cogens does not automatically bring up certain obligations of prosecution or accountability. And you know what? Because that's the reality of power. Countries, ultimately international law is created, of course, by the eminent scholars on this panel, Phoebe, Erica, and Charles, but it's really primarily written by states. And states don't have much of an interest in giving jus cogens that enforcement edge, because it's going to be used against them. That's the reality of international law, and that's how it operates. Going back to Phoebe, maybe we should, as the French say, bon courage at sort of chipping away at these maybe vestiges of the power relations of international law, but that's how the system operates. And thank you.
You're muted, Charles.
Unmute.
I was saying thank you very much to Mohammed for those interventions. I think you addressed a number of the questions that were raised in the chat, so I'm grateful for that. All of you, I think, have done a fantastic job in terms of this very difficult subject that we've begun to discuss today. I note that there are, of course, additional points that we couldn't fully develop from a couple of, I think, chats. Someone mentioned the African the African Union effort to criminalize the crime of aggression and the domestic implementation in South Africa of legislation that excludes that crime. I think the Malabo Protocol does include the crime of aggression. The challenge there is that we have 15 signatories last I checked, but not a single ratification by an African state, and yet you need 15 African states in the AU practice for the instrument to become to come into force. So in fact, there is a crime of aggression. In Africa, it's possible, in fact, in the way it's defined, to even use the crime of aggression against non-state actors. It's fascinating element of the Malabo Protocol, which has a lot of ambition in it in many ways. On jus cogens, I could not resist but to plug that the International Law Commission has been doing some work on clarifying jus cogens. I guess it's for Mohammed and others in academia who are more distant from the issue to tell us whether jus cogens is of use and whether the work of the International Law Commission adds value in terms of clarifying the substantive ideas, especially given that we attempted to deal with some aspects of the legal consequences of jus cogens. But again, I mean, this is it's in the ether out there, so I just wanted to just add that in as a substantive point for those who are still in love with jus cogens. I have to say I may be one of them. So anyway, on that note, I want to just take this opportunity to thank these fantastic colleagues who've taken time out of your very busy schedules to share really deep insights. It's always important to hear when you talk about a perspective, and you talk about African perspective, there's not a single African perspective. What we've heard, a rich variety of African perspectives on very, very difficult and challenging questions. In many respects, I think is the opening of a conversation. So I'm going to be inviting back all these panelists. If they will bear with me to come back one more time, I'll come back calling, because I do believe that this insights that you've offered, I haven't heard a lot of these points from other people in other panels, and I've been following generally a lot of what's been discussed. But so there's a space, in other words, for African views to come out, including also in aspects that we haven't developed that are quite important. This point about nuclear proliferation potentially being a problem. Yeah, it's a very fascinating, and there are people doing work in Africa on issues of nuclear proliferation. We know that South Africa also was one of the countries that harbored nuclear ambitions, and at one point and seems to have stepped back. But if your security is only going to be guaranteed if you have the weapon, what does this mean now? So there are many, many questions of international criminal law, questions of state responsibility, the issues at the International Court of Justice. We didn't even discuss them. But again, just to say, this is the beginning of a conversation, not the end of a conversation. So on behalf of myself, and the Center for International Law and Policy in Africa, and our partners, the Nuremberg International Principles Academy, as well as the American Society of International Law. Thank you for sharing your day with us, or at least part of your day with us. We look forward to engaging with you further. Please look out for our emails. Have a good one, everybody.
Bye.
A big round of applause to all the participants and the speakers. Thank you. Bye-bye.
Bye-bye.